going to call the House Judiciary Committee to order. Madam Clerk, will you please call for attendance?
Chair Lightner.
Here.
Representatives Begol.
Here.
Wozniak.
Here.
Harris.
Here.
DeBoyer.
Here.
Johnson. Here. Schutte.
Here.
Carter.
Here.
Hope. Breen. Scott. Present. Madam Chair, you have 9 members present. You do have a quorum.
Thank you, Madam Clerk. Rep. Johnson moves to adopt the minutes from 11:05. Hearing no objection, minutes are adopted. Rep. Wozniak moves to excuse absent members. Hearing no objection, absent members are excused. All right, next up, we are going to address House Bill 4284 by Representative Paquette. I have a couple of cards to read in regards to that bill. Not wishing to speak and supports the bill, Casey Armitage from representing herself. Supporting the bill, not wishing to speak. Also opposing House Bill 4284, not wishing to speak, Denise Harsov of League of Women Voters. And then we also have an amendment. Representative Carter, do you wish to speak to your amendment in regards to 4284?
Yes, and thank you, Madam Chair. In regards to the bill, if we want to have an honest discussion about who's going to pay for this and the CPL background checks and the database, CPL applicants in Michigan Michigan taxpayers, then let's have that discussion. This bill does nothing more but transfer the cost of the CPL background checks and its systems onto Michigan taxpayers to the tune of $8.1 million, according to House Fiscal. As a CPL holder and taxpayer, I don't want the cost transferred onto Michigan taxpayers. With that, I move my amendment.
Thank you, Representative. Madam Clerk, can you please call the roll for Rep. Carter's amendment?
Chair Lightner.
No.
Representatives Begol.
No.
Wozniak.
No.
Harris.
No.
DeBoyer.
No.
Johnson.
No.
Schutte.
No.
Carter.
If I say yes loud, would it count?
Only one
Yes.
vote. Breen, Hope, Rep. Hope, Breen, Scott.
Yes.
Madam Chair, you have 2 yeas, 7 nays, and 0 pass. The motion does not prevail.
Thank you, Madam Clerk. With that, Rep. Begol moves to report House Bill 4284 with recommendation. Madam Clerk, please call the vote.
Lightner.
Yes.
Representatives Begol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Schutte.
Yes.
Carter. Hope. Breen. Scott.
No.
Madam Chair, you have 7 yeas, 2 nays, and 0 pass. The motion prevails.
Thank you, Madam Clerk. Next up, we have House Bill 4947 by Rep. Begol. I'll have Rep. Begol move his bill. Moves to report House Bill 4947 with recommendation. Madam Clerk, please call the vote.
Chair Lightner.
Yes.
Representatives Begol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Schutte.
Yes.
Carter.
Yes.
Hope. Breen. Scott.
Yes.
Madam Chair, you have 9 yeas, 0 nays, and 0 pass. The motion prevails.
Thank you, Madam Clerk. Next up, we have House Bill 4948 by Rep. McFall. Rep. Wozniak moves to report House Bill 4948 with recommendation. Madam Clerk, please call the vote.
Chair Lightner.
Yes.
Representatives Begol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Schutte.
Yes.
Carter.
Yes.
Hope. Breen. Scott.
Yes.
Madam Chair, you have 9 yeas, 0 nays, and 0 pass. The motion prevails.
Thank you, Madam Clerk. Next up, we have House Bill 4749 by Rep. Roth. There is an H1. I'm going to explain the H1. It'll change the effective date to 12 months after the adoption of the bill, so there's additional time to restructure the courts. In addition to the substitute, the names of the courts will be 86A District Court for Antrim, 86B for District Court for Grand Traverse and Leelanau. These changes were at the request of SCAO and the bill sponsor. With that, I will move the H1 substitute to 4749. Madam Clerk, please call a vote.
Chair Lightner.
Yes.
Representatives Begol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Schutte.
Yes.
Carter.
Yes.
Hope, Green, Scott.
Yes.
Madam Chair, you have 9 yeas, 0 nays, and 0 pass. The motion prevails. The sub is adopted.
Thank you, Madam Clerk. We'll do Rep. Harris moves to report House Bill 4749 as substitute H1. Will the clerk please call the vote?
Chair Lightner,
Yes.
Representatives Begol,
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer,
Yes.
Johnson.
Yes.
Shudy.
Yes.
Carter,
Yes.
Hope, Green, Scott.
Yes.
Madam Chair, you have 9 yeas, 0 nays, and 0 pass. The motion prevails.
Thank you, Madam Clerk. All right. Next up, we will have testimony on House Bill 4586 by Representative Wolford in regards to CPL licenses. Rep. Wolford, you have the floor, and with you, wishing to speak in support of the bills, Nick Bougie, Brady, I slaughtered your name last week, sorry. Yeah, that, I'm gonna call you Brady, yes. Thanks. From NRA and Michigan Coalition for Responsible Gun Owners that are testifying with you. You have the floor, Mr. Representative.
Thank you, Madam Chair and members of the committee. House Bill 4586 makes a simple but meaningful update to our current law in the state of Michigan, and that is lowering the minimum age to obtain a concealed weapon permit, or a CPL, from 21 to 18 years old. Now, this bill does not change background checks, training standards, or disqualifying offenses. Every safeguard that exists in our current concealed carry process remains fully intact. The only change is recognizing that an 18-year-old adult, someone that has the ability to vote, pay taxes, live independently, serve on a jury, and enlist in our military, should be trusted to exercise the same right of self-defense and rights of every other law-abiding citizen. Right now, Michigan tells us that an 18-year-old soldier or Marine that are mature enough to deploy overseas and carry a service weapon for our country, but somehow is not responsible enough to carry a sidearm to protect themselves in their own neighborhood. This doesn't make sense to me. At 19 years old, I fired an M60, a .249 saw, a 50 cal, threw frag grenades, fired a rocket launcher, and shot 9mm. But if the times were at the time I was 19, I would not be allowed to buy a pistol. Ironically, too, in the state of Michigan, at 18 years old, you can buy a pistol from a private individual, but you can't walk into a store and buy one, and that seems out of order. So the truth is, young adults today face the same risk as anyone else. Many live alone, they attend college in cities, they work night shifts, and they deserve the same rights and ability to defend themselves responsibly. And so to be regulated license process that includes the same safety training and background screening, et cetera, as mentioned before. This bill ensures that responsible trained 18-year-old to 21-year-olds can exercise their constitutional rights within the same framework as everyone else, lawfully, safely, and with accountability. House Bill 4586 is about consistency, fairness, and common sense. It's about trusting legal adults who simply meet every requirement we already have in place. It ensures that we treat them as responsible citizens, not second-class adults under the law. And in closing, we have some that believe that 16-year-olds should have the right to vote, and also children younger than that, the ability to cut off appendages on their bodies, but we won't allow an 18-year-old to have a gun. That seems wrong and is wrong. So thank you, Chair. I'm happy to take any questions from the committee.
We're going to go ahead and just go to testimony, and then we'll do questions.
Thank you, Madam Chair, members of the committee. So as we've established, 18-year-olds are adults under the law. At 18, you have every full access to every other constitutional right except for the Second Amendment. You can vote, you can sign contracts, you can take out tens of thousands of dollars in student loans or hundreds of thousands of dollars to buy a house. You can marry, you can serve on juries, and as the representative said, you can serve and protect our country. Restricting these rights creates an inconsistency in the law. Under the Supreme Court's Bruin decision, in the opinion they wrote, ultimately the text of the Second Amendment includes 18 to 20-year-old individuals among the people whose right it is to keep and bear arms. There have been several legal precedents since then in lower courts that have struck down the limitations on those between 18 and 20-year-olds to carry or to conceal carry. This law would just sort of be in line with that, and we've decided that 18-year-olds are adults. This is just giving them their full rights as adults, and letting them carry on as such.
And thank you, Madam Chair, for taking up this bill. House Bill 4586 would create uniformity of age in Michigan firearms law. As the representative stated, it's already legal to purchase and possess a pistol in Michigan at age 18. It's also legal to openly carry a pistol in Michigan at age 18. What we're talking about with 4586 is concealed carry. And this bill would actually improve public safety because concealed carry requires licensure with background checks, following a minimum of 8 hours of legally mandated safety training, including live fire exercises on a range with a qualified instructor. The focus should be on who is responsibly trained, qualified, and vetted, rather than the young adult's age.
Sure. Well, I do want to make one comment. Thanks, Rep. Wolford, for bringing this up. Living on a farm, we are very familiar with firearms. My sons are both very familiar with firearms. You can also take the class for a CPL. You just can't actually get your CPL. So they can do the safety training at any time as well, which is craziness that they can't actually carry, concealed. I appreciate this bill as well. So my son, who's now 20, could still possibly be able to carry at some point before his 21st birthday. But, you make good comments about all the other things you can do in this country at age 18, and then you can't carry a pistol under your shirt, but you can openly carry it. It's just silliness. So thanks for bringing that. With that, we have Rep. Harris with a question.
Thank you, Madam Chair. Rep. Wolford, thank you again for bringing another good bill to us. And thank you both for being here. I know you guys are very active in the responsible gun owner community, and I appreciate that. I've been a firearms instructor since 1997 and former law enforcement, and I am still happy to see the ability for an 18-year-old to be able to legally carry concealed. I think it's a great idea. I think it's one more thing that helps make our community safer. And one thing that didn't get mentioned, in the state of Michigan, you can be a police officer at the age of 18 and can't even purchase your own ammunition. It's kind of bewildering to me. So again, thank you for bringing this up, and I think it needs to happen.
Rep. Carter.
Thank you, Madam Chair. How many other states, what is the average age of other states? Or is Michigan an outlier?
I can get you the exact number. I believe there are 15 states currently that allow 18 to 20-year-olds to carry concealed, but I can confirm that for you.
Okay. And what's the age for buying beverages, alcohol in the state of Michigan?
Well, that's not a constitutional right, but
But what is it?
it is 21.
Okay.
Okay. Thank you, gentlemen. Next up, we're going to have Casey Armitage, wishing to speak, supports the bill 4586, and would like a little time to speak.
Thank you, Madam Chair and Committee, for hearing from me today. I am Casey Armitage, and while I may be the president of Michigan Open Carry, I am here today as a veteran's wife and a mother. My children are currently 18, 20, and 21. I have been waiting for this bill for so long, and I'd really like to see it go through. My children should have every ability to provide their own self-defense as I do. We've talked about the open carry of 18-year-olds, and while they're able to do it, this bill would clarify and help so many bad things from happening, because the difficulty that it is to legally open carry at 18 years old is incredibly difficult. Other than taking a stroll down a public sidewalk, you're very limited. You can't enter a business that serves alcohol or sells alcohol. You can't go by the schools. There's so many things you can't do. So this would really clarify and solidify our young adults to be able to carry and do so responsibly and with the knowledge that they need to do that for themselves. So as a wife and a mother, I am absolutely here in support of 4586. Please let my babies protect themselves.
Okay, seeing no further questions, thank you, Representative. We are going to move on to the next bill. So I'll call up Rep. Outman on, oh wait, let me read these cards. Okay, in regards to 4586, not wishing to speak and opposes the bill, Kathy Tang, Every Town for Gun Safety. There is somebody that wanted to speak. Gail Duncan from Moms Demand Action opposes the bill and wishes to speak. Thank you. Sorry, Gail, that I missed that. I'm going to have two more speakers. You have the floor. If you could stick to 3 minutes, that would be great. It doesn't matter, either one.
So, good morning, Chair Leitner and members of the House Judiciary Committee. Thank you for acknowledging my testimony today, and I do appreciate this opportunity. My name is Gail Duncan. I'm a resident of Charlotte, Michigan for the past 25 years, and I've lived in Michigan my entire life. I joined Moms Demand Action 7 years ago after my young adult daughter was murdered at her place of employment in broad daylight with customers and coworkers present in the building. The gunman then took his own life, changing the lives of 2 families forever. I am testifying today in opposition to House Bill 4586, which is a bill to lower the age to obtain a concealed carry permit to carry concealed loaded guns in public from age 21 down to age 18. As you probably know, firearms are now the leading cause of death for American children and teens in America. House Bill 4586 would set a dangerously low minimum age for carrying concealed loaded handguns in public, despite research that shows that individuals aged 18 to 20 years old commit gun homicides at a rate of approximately 3 times greater than adults 21 and over. The area of the brain responsible for judgment and impulse control is not fully developed in 18, 19, and 20-year-olds, meaning that they can be more prone to aggressive behavior. Decades of scientific evidence demonstrate that adolescents and young adults make riskier decisions than adults. Unfortunately, our state and communities know all too well the devastating impacts of gun violence. In the Oxford High School shooting, a 15-year-old shot and killed 4 students and injured 7 others with a handgun. Gun violence in the United States steals nearly 46,000 lives each year. That includes the lives of almost 1,420 Michiganders, costing $16.8 billion in employer, work loss, medical, police, criminal justice, and also loss of quality of life cost services. I urge members of this committee to please oppose House Bill 4586 and prioritize the safety of our communities by focusing on proven solutions to gun violence prevention. Thank you very much for your time.
Thank you. I lost my card. I have lots of them up here. Next up, wishing to speak and supports the bill, Tom Lambert of Michigan Open Carry. If you would like to approach the table, that would be great. Thank you.
Members of the committee, Madam Chair, thank you for the opportunity to speak. It's good to see you all again. If you don't recall, last week I am Tom Lambert. I am the Legislative Director for Michigan Open Carry. I've been doing this for roughly about 15 years. I've addressed this issue a couple times privately, but I think this is my first time in committee. There are some misconceptions about Michigan Open Carry and open carry in general. One of those conceptions is that people who openly carry do not have a CPL. That is wrong. In fact, Michigan Open Carry strongly advocates that people who do openly carry a holstered pistol get their CPL. And one of the main reasons we advocate for that is all of the legal pitfalls that simply having a CPL takes off the table. One of those pitfalls is that Michigan has a 5-year felony for carrying a concealed pistol or a pistol otherwise carried in a vehicle. We are one of the most draconian states in the nation in terms of we have a very strict punishment, a 5-year felony, not a lesser felony or a misdemeanor, and we cast that felony against a very, very wide net. It's not just something loaded on your person. It's unloaded, it's anywhere around you, it's anything in your vehicle. It's an incredibly wide net combined with a very, very strict punishment. Simply having your CPL takes that off the table. Now that the weather is getting colder, we also have an issue with what you wear. If your shirt slips over the holster of the firearm, if your coat slips over the holster of the firearm, even for a moment, you can be subject to prosecution under that felony. And I'm telling you affirmatively, with strong conviction, that this felony is absolutely enforced against inner city minorities far more than anyone else. Allowing 18 to 20-year-olds not to carry, because that's not the issue on the table. They can already carry, as you've heard. Allowing them to go through the training, go through the background check, and simply get the licensing, again, to take those pitfalls off the table, whether it's carrying out in public or transportation. If you do not possess your pistol correctly in your vehicle while traveling to or from a gun range, again, you can be subject to that 5-year felony, even though you didn't have it loaded on your person, you weren't even trying to carry it. You can still be subject to those crimes. The possession of a taser is completely off the table for these individuals. We talk about firearms. Tasers, you have to have a CPL in Michigan in order to lawfully possess one at all, even just in your home, not even outside the home. Indiana is an excellent example. Indiana offers lifetime licenses, we talked about those CPL fees, to 18-year-olds. 18-year-olds can lawfully carry concealed pistols in Michigan if they are from another state that issues to 18-year-olds like Indiana does. I'm not aware of any instance where an 18 to 20-year-old that's lawfully licensed in Indiana and lawfully carrying in Michigan has done anything nefarious in this state, let alone even in Indiana. By and large, CPL holders are law-abiding people. The data shows this all across the nation. They tend to be more law-abiding than law enforcement. They tend to be more law-abiding than the judiciary. They tend to be more law-abiding than even the legislative branches of their particular states. Madam Chair, I have a few comments on the other bills. Would you like me to reserve those or quickly get them out?
No, I can call you back up if you don't mind.
Happy to defer to you.
Thank you.
Thank you for your time, unless there's any questions.
Rep. Wozniak.
Madam Chair, has there ever been shown a correlation between legalizing for 18s and a CPL versus unlicensed guns or illegal guns that are on the street?
Forgive me, Representative, I don't quite understand the question.
Well, usually there's a unintended consequence, like what we did with marijuana. We tried to cut down the black market. So is there a black market in guns that would be diminished by having a legal CPL?
Is the question, is there any correlation that I know of between allowing 18 to 20-year-olds to get a CPL and an increase or decrease in unlawful gun possession on the streets? Decrease. I'm not aware of any correlation one way or the other. I know this is somewhat newer. The only thing I would point to in a micro context is that the individuals who might otherwise be said to be unlawfully carrying, even though they really weren't, they didn't tend to harm anybody, their coat just happened to be covering a pistol, that's technically treated as unlawful carry, even though it shouldn't be, that we could expect to see a decrease in that.
Okay. Thank you.
Thank you for your time.
Thank you. I think that is the last one on that bill. Yes. Okay. Now Representative Outman, thank you. 5113. And it's my understanding that you have people with you as well that'll testify on Zoom.
Yes, I have
Yes.
2 people that I am aware of awaiting on Zoom right now.
Steve Dolan from Michigan Responsible Gun Owners will be testifying. So after you're done, I will have Steve Dolan speak, and then Chris Millard from the county clerk's office.
Could we do it the other way around?
Sure.
Okay. That would
You
be
call
great.
on him when you're done.
Perfect.
Thank you.
Well, thank you, Chair Leitner and members of the committee. I appreciate the opportunity to testify on my bill, House Bill 5113. This bill addresses an issue that was brought to my attention by my Montcalm County Clerk, Kristen Millard, who you will see testifying right after that. She was seeing some recurring problems, particularly with folks renewing their CPLs, causing a lot of grief, costing applicants extra time, money, frustration, that sort of thing. So after I finish my remarks, like I said, Chris Millard will share a little bit more about what she's been experiencing at the county level. Following her, you'll again hear from Steve Dolan, General Counsel for the Michigan Coalition of Responsible Gun Owners. Steve worked with Clerk Millard and me to craft this legislation and ensure we address the correct areas of law. But as you see, the main objective of House Bill 5113 is simple. It's to create a clear process for correcting errors on CPL applications to allow a short grace period while those issues are fixed. At the end of the day, this bill is about fairness and efficiency. It just ensures that law-abiding CPL owners aren't punished for simple errors or administrative mix-ups, and that our clerks have that flexibility that they need to resolve these issues quickly and without unnecessary costs. So with that, I will turn it over to Clerk Millard to share her perspective from the county level.
Good morning, Chair and the committee. Thank you for allowing me to testify. My name is actually Stephanie Bracey, and I am Chris Millard's Chief Deputy Clerk. She was unable to attend today, but I am here to testify on her behalf. So to kind of go to the point of Representative Outman, our concern came when the beginning of the year, we started to have applicants that were actually renewing their CPLs. And what was happening was they were coming back as disqualified. And what it was showing for disqualification were pending criminal charges that were from the early 1990s. And these didn't show up on previous applications that they did. They had been CPL holders. We had a gentleman that was a CPL holder since 2005. He never had an issue with this. And then all of a sudden this year it was showing up and it was having him be disqualified. I had contacted the Michigan State Police on how we should handle this. And because it was a court's error that his disposition of the charge was not handled properly. It was not his fault. So what we went to Representative Outman was that we didn't feel that it should have been the individual's responsibility to have to pay that $115 renewal fee. Again, for the second time, MSP did a workaround for them to be able to just reapply and not have to retake the class again, that they still could reapply, but it still would cost them another $115. So what we went to the representative's office was try to get some legislation passed that would allow for these mistakes to be corrected, possibly in a time frame where they wouldn't have to repay that $115. Now, we don't have a ton that come through like this, but we are still seeing them. The most recent one we had was in August of 2025 that he was disqualified. He had been a CPL holder for many years, and it was just now showing from the background check that they did. And that's all that I have for today. I just wanted to give a brief synopsis of what we were seeing. If you have any questions, I'd be happy to answer anything. Thank you.
The timeline in the bill's business days, is it 21 business days to remedy the situation? Like, is that enough time to deal with the court system and the state police? Like,
I mean, as far as a smaller county, probably, but some
Okay.
of our larger counties, it could take a lot more time for people to get it resolved.
how long did it take for you? I mean, were they expeditious in getting it done, or just, I'm
Well,
just curious.
in our office, we're in charge of, so how criminal histories used to be sent in the 90s was they had the judgment of sentence, once they were sentenced, was mailed into the Michigan State Police and they would manually update their criminal histories. Now, when we do a judgment here in the clerk's office, because we are the clerks of the circuit court, that judgment electronically gets sent. So it's very fast that MSP is able to get it updated on their criminal history. So the one individual that we had, we were able to go in and see what had happened that wasn't sent properly. We got it sent right over and they were able to fix it rather quickly. But that was in our court. So I can't speak for other courts, unfortunately, how quick it would be for them to do it. Like I said, some of the bigger counties, it probably would take a lot more time.
Okay, thank you. And then next up, we have Steve Dolan. Go ahead, you have the floor.
There, I think, sorry, I was unmuting. Yeah, hi, I'm Steve Doolin. I'm a member of the Board of Directors of Michigan Coalition for Responsible Gun Owners. I'm also an attorney in private practice. I handle a ton of firearms cases, and I am the professor of firearms law at Cooley Law School. And as Representative Altman mentioned, I was honored to be included in the discussions leading up to this amendment that is in this bill. And I would just like to throw in with regard to the last question that the language actually here says that the 21 days applies if it's a mistake by the applicant. And if it's a mistake by someone other than the applicant, then the applicant can resubmit at any time without paying the additional fee. And that was because in my experience dealing with a lot of counties, we've got spotty reporting, frankly. Just kind of depends on the court whether or when a lot of things are reported from the courts to the relevant database here at MSP. And then there's another glitch that happens between the local database in Michigan and the federal database at FBI NICS, but that's not really the subject of this. But we've got a lot of time. I think the question was right on point. We've got a lot of time taken up trying to correct these errors in a lot of cases. So there's two different time frames here in this language. 21 days is if the applicant makes a mistake. And I've seen a fair number of those in my practice, in part because there's a way to do this online, and a lot of people are doing it on their phones. And if you've got a fat finger or you don't read the small print clearly enough, you can click the wrong box, essentially. And then under the current system, even if you say oops within minutes after, which was the case for one of my clients, under the current system, you've got to wait for the denial and reapply starting ab initio, right, from the beginning. And so this seems like common sense to me. This is just, if I get turned down on a renewal because I made a mistake, or I checked the wrong box on the form at the clerk's office, either way, then I've got 3 weeks to come in and prove, and the clerk gets to look at documentation here, and we're already relying on the clerks to review the relevant documents. Then the clerk can say, okay, gotcha, I see the mistake here, and it can be corrected that way, and the application can proceed. And then if the courts forget or fail to report something like the incident that we just heard about, then there's actually at any time language in here.
Thank you. We have a couple of questions. Rep. Carter.
Yeah, thank you, Madam Chair. And it was probably for the clerk before when she talked about the situations that I'm curious, and maybe the attorney can answer. How often does this happen, or how often does this come to your attention?
Well, it's come to my attention several times. I tend to get calls from all over the state with regard to these types of issues. So no one's gathering this data. Nobody knows how many people simply just kind of sucked it up and went through the process again and paid the fee and had to start all over. Nobody's got that data.
Okay, because you did raise a great point about the 3 weeks if it's a situation by the applicant. But is there a timetable if it's by the courts or the clerk's office?
No, the language that's in here says may submit a new application at any time.
Okay, thank you.
Rep. DeBoyer.
Thank you, Madam Chair. So I spent 12 years as county clerk, and this was a very common issue. And I appreciate you guys coming forward with this, because things as simple as mistakenly checking the wrong box on a question would disqualify an individual, even though their answer was not actually the accurate answer. And I'm going by memory. It's been a couple years now since I've been there, but it seemed as though there was actually a period of time they had to wait to reapply, even when it was just a mistake that they had made. The other issue is that we may think that the courts all talk to each other, right? They don't all talk to each other. So when a rejection comes back, and the local clerk provides that letter of rejection, it's on the applicant to go to the court of jurisdiction that the denial came from, and try to get that sorted out. And we had that happen many, many times, which resulted in them then having to get a new entry into the lien system that showed that had been dissolved or had been adjudicated and they weren't subject to it. I mean, it was quite a process, and it ended up costing applicants the additional $115 application fee, or sometimes $115 already on prints. But it was an ongoing problem that we dealt with almost on a monthly basis to one degree or another. So, Rep. Altman, I really appreciate you coming forward with this bill. This really does make a difference. And thank you guys for what you do, by the way, up there.
Can I add something to that? The prior comment. I've got a paralegal here in my office who averages about 2 days a month of billable time cleaning this kind of thing up for people. They're just courts not reporting, et cetera. So they're not only paying the $115, they're paying law offices also.
Thank you. I'm going to go ahead and call up Tom Lambert again on House Bill 5113. You can just stay there, Rep. Altman. Supports the bill, wishes to speak from Michigan.
Our support and return the balance of my time unless anyone has a question.
Oh, thank you, sir. All right, I'll read on the rest of these cards. Not wishing to speak, supports the bill, Casey Armitage. Not wishing to speak, supports the bill, Nick Bougie from NRA. Not wishing to speak and supports the bill, Brady from MCRGO. Brady, yes. I'll write it out phonetically so I can say it right. All right, next up, we are going to have Rep. Maddock up on House Bill 4980 in regards to CPLs also. And with him, he also has Representative Gary Eisen, who supports the bill and wishes to speak with him.
You know, one of the greatest things about this country is our ability and right to defend ourselves against bad people. And I think the last person that should get in the way of that sacred right that many of us enjoy in this room is a bureaucrat, and that's happening in Michigan. And this is actually a reintroduction of a bill that Representative Eisen got through the House a couple years ago, and it had a lot of support because this bill does make sense. It actually had 20 Democrats on the bill also who voted in favor of this bill. So I want to let Gary, who's had a lot of experience in this arena, he's been a CPL instructor for many, many years, and he's had feedback from a lot of people that he's trained when they hit these roadblocks and these horrible things that some of our counties are doing to people.
All right. Thanks, Madam Chair and committee members. It's been a while to sit in this chair, but kind of all comes back to you know. But yeah, I've been a CPL instructor for 20 years, and it came to my attention that I was doing most of my classes in Macomb and St. Clair County. All right, pretty, I call them normal counties. But when I came to Lansing, I was starting to do classes for members and staff, and they came from different counties. And I was getting complaints from them that when I told them about getting their CPL, you go to the county clerk's office, you fill out your application, you pay your fee, and away you go, you get fingerprinted. And it was like the same day, maybe 1 day delay. But some of these guys were saying they had 4 months, 5 months, 3 months, and it just didn't make any sense to me. Why some counties can do it in a day, and other counties take 5-6 months. And so being in the position I thought, well, maybe I'll look into this, and maybe we can pass some legislation to straighten this out. And at the time, I had my back desk, Nancy sitting behind me, called several county clerk's office and asked them about the waiting time. And we had all kinds of times, from a day to, like I say, 6 months. And I'm going, why is this? And we found it not to be red and blue and all that kind of stuff, but we did find that more of the blue counties took a little bit longer than the red counties. That's just a fact, okay?
Who was the longest wait?
Wayne County was the worst with a 4 to 6 month waiting period. And it just didn't make sense to us. So I did pass a bill. We called it our Any County bill. It was about 3.5 years ago. And it did come out of committee, bipartisan, came off the floor bipartisan. And it got stalled in the Senate. And one of the big reasons it got stalled was that the county clerk association came out against it. And it wasn't for any real reason except for the money. The county clerks wanted to keep the money. So if more people left Wayne County, went to St. Clair County would get the fee. And my answer to them was, well, if you just got more efficient in doing this, people wouldn't feel the need to leave your county and go for it. So you got under your driver's license is a state license. Your CPL is a state license. All right. You can go anywhere in the state and renew your license. Okay. But you can't do that with your CPL. But you got to understand, all this information goes back to the state police. So it really doesn't matter where you file. The state police have the last call on it. They're the ones who okay the applications. They certify it. So if someone is in one of these counties with a waiting period and they decided to take a day off of work and drive up to Macomb or Sand Lac or one of these counties that pretty much same day application, why is that such a crime? Okay. Why are we punishing law-abiding citizens because of a waiting period? It just didn't make any sense. And I got to remind everybody that this bill is not about buying guns or shooting guns or transferring guns. It's simply about filling out a piece of paper and giving it to the clerk and paying a fee. That's all it is. It's logistics. And whether you fill that out in St. Clair County or fill it out in Macomb County, who cares? That's my opinion. That was my opinion. Okay? And it just seems to me it's a very common sense bill. And now some people get their CPL for personal protection. Some just get it because it's easier to carry, and some get it because it is easier to buy a firearm with a CPL. But to go through that whole process just to be told it's going to be another 4 or 5 months, it just didn't make sense to me. And that's why I put the legislation through before. And like I remind you, it was bipartisan. It came off the floor. And I thought it was a good bill, and I still think it was a good bill. And if I got reelected this last term, I was going to run this bill again. Okay? That's just the way it is, because it was a good bill. I don't see really anything wrong with it, except for the opposition we had. And that was all about money. And it's too bad that money has to stand in the way of people getting that CPL. And more, after COVID, just seems more and more people are filing for their CPL, especially women. My last class 2 weeks ago was 7 women, not a guy in the class, all right? They all just wanted to be more responsible for their safety. They want to have more of a input on how they can protect themselves. And then I'm going to tell them that it's going to take an extra 3, 4, 5 months to do this. It just didn't make sense to me, and that's why I'm glad Matt had me come in to speak on behalf of the bill. And I'm willing to take questions, or Matt's willing to take questions, I think.
It's great having you, Gary.
I'm glad you asked me.
All right. Thanks, fellas. It's good to see you again, Gary. For those that didn't know, Gary sat behind me for a couple of years on the House floor, so good to see you again.
Ammo?
Yeah, I used it.
No, I said, did anybody else give you ammo?
No, Gary. Oh, yes. Gary, got me a present every so often. He'd bring a box of ammo, and that's always beneficial.
Yeah.
But anyways, we do have some questions. Rep. DeBoyer.
Gary, thanks, Madam Chair. Thank you. Gary, thanks for being here. I remember the conversation about this back in the day.
I called you.
Yes. And we did a really good job in St. Clair County getting these things out. But then when you went south, it was like months and months and months. You're right. It was all about the money. The opposition from the County Clerks Association was all about the money. That's really all it was about. But additionally, was it about 2012 when it went to the shell issue, roughly? Is that right? About 2012. See, if you remember though, we used to have a county gun board, right?
Oh, that was
And there was a little bit of discretion in that county gun board, right? Which you could make an argument that maybe that's why we want you applying in the county that you live in, because if the prosecutor had a relationship with you, good, bad, or indifferent, there might be, but that's gone. That doesn't exist anymore. It's a shell issue. If you qualify, you qualify. So I think it's a great bill. Representative Maddock, thank you for bringing it up again. It makes sense to service the citizens of the state of Michigan. So I'm completely in favor of this, but great job. Good to see you, Gary.
Rep. Breen.
Thank you, Madam Chair. I'm gonna break my rule and ask a question I don't know the answer to. So I'm wondering about what discussions you've had with the clerks. They've had a lot of changes thrown at them lately, especially in regards to elections. I know they work hard. What I don't know is between the different counties, do the clerks use different systems? Is this going to be possible for them to implement? Is there a cost involved? And I know that you might feel like down south, they're just delaying on purpose. I personally don't think that's the case. The bulk of our population is in southeast Michigan. So there's probably more applicants. I'm just wondering about the feasibility and whether or not there are going to be any glitches if they start in one county and then finish in another.
Okay. Now you got to remember, I introduced this 3.5 years ago, so all my data was from 3.5 years ago. Now, in the meantime, if the county clerks have improved their system, more power to them. Now, I don't know how it's done. I don't know if it's politically motivated. I don't know. I really don't care. I just think that it should be more of a level playing field for everybody. Now, is there a cost involved? Yes, they get a fee off that fee that I paid to get renewal. They get a fee off it. And if that's the case, if that's the case, they're worried about the fee, which they did tell me that. That was 3.5 years ago. And that was the stumbling block at the time. Now, whether or not that's today, I don't know.
I just don't know if they have different systems that they work with as far as the technology.
Well, the way I look at it, every county has the mechanism in place and the procedure in place. And the counties that are doing a large volume are making a lot more money off these to cover their costs. So in my opinion, there's no excuse for Wayne County or Washtenaw County to have a long waiting period because they're getting that additional revenue. And of course, they're always opposing anything we do because no one in government wants change. But this is an improvement on what they do.
My opinion to them. Oh, sorry.
Oh, I was going to just let Rep. DeBoyer intervene in this question.
So thank you, Madam Chair. So there's a state system that CPL applications are processed through. And when you process them through, you enter all the pertinent information, including your counties that you're in. And then when the approvals come back, that comes back through that state system back to the county of issuing. So what that would mean is that if you came to St. Clair County and you filed your application, St. Clair County could process that application, but when the CPL is issued, it would be issued back through the county of your residence, which then they could distribute that as they do currently, right? They do that currently. It doesn't change. The additional thing is on an annual basis, you have to do a report to the state police on CPLs issued, both renewals and news, revenue that's been taken in on that, and your operational cost for you to execute that activity. So if you're executing that activity and you're taking the money in, it's helping to defray the cost. But if you're not executing that, you don't have the expense, right? So that entire system and structure exists. By the way, that data is readily available from every county, how many they've issued and what their operational costs were. And I've looked at that data, and it's pretty amazing to me to look at some of the counties that operate in the black versus the counties that operate in the red, that it costs them more to process a CPL application than it does that they take in, and it's rather telling. So this would again go to the premise of efficiency, who does it the best, who does it the quickest, and frankly, that's where I would rather give my business, is the place that does it the most efficiently and most quickly as a taxpayer.
Thanks. Rep. Carter.
Thank you, Madam Chair, and good to see you, Rep. Hate to spoil this, but everything's about the money. And you brought up a great point. Driver's licenses, Secretary of State, state police. How about we move it to the state?
I had mentioned that several times. The Secretary of State could probably do just as good his job, since you have to go there anyway.
You'll have one standard.
Exactly. I mean, I'm not against that, and I actually brought that up years ago. And I actually believe the state police could do it all on their own too, since everything you do goes to the state police for approval. And then they send out your CPLs, they mail them out, okay? I believe they mail them out. So could the system probably be better? Yes. The old county boards were terrible. They would only do so many a month, and they'd pass them to the next month, pass them to the next month. And what happened was, all of a sudden, you're 3 months down the line and your name hasn't come up yet. Now, my first original CPL is I had to go in front of a board with state police.
That was probably a musket gun, sir.
And that was like the Spanish Inquisition, okay? I mean, they just railed you on why you felt you needed this and all that kind of stuff. But we come a long way since then.
So, would you be open to that?
I would be.
All right, thank you.
I was for it before, so.
Yeah, and to that, I actually renewed my CPL online this last year through the state police website. It was super easy. I just had to have a PIN number for my county clerk, which she actually had to, send me twice because I lost it apparently. But, it was super simple. They already have all the information anyway. But I will call up the next one. Tom Lambert, if you'd like to speak again, supporting the bill, you can come on up.
Members of the committee, thank you again. How about some history? Rep. DeBoyer, you were talking about some history here. 1887, Michigan, one of the first states, criminalizes the possession of concealed handguns. Fast forward to 1911, we actually created the county gun boards in 1911, but only required the license for counties with a certain population level. Very few counties at that time. Jump forward again to 1925. That's when we expanded those county gun boards to the extent that we used to know them. Jump again 2 years again to 1927, where they effectively redid the 1925 law. And ever since, it's been this 1927 law that we've amended over and over and over again. That's why it's all referenced to Public Act 372 of 1927. Back in 1927, we did not have computers. Everything was local. In 2000, that's when we went shall issue, where we said you can't just decide to deny people. If they meet the criteria, you have to issue a license to them. But everything was still through those county gun boards. I want to say sheriff, state police, and local prosecutor were the three members of the county gun boards. In 2015, that's when the law passed. It was Public Act 3, if I recall, and effective in 2015, got rid of those county gun boards. We're not done yet. 2 more years, 2017, they came back and had a cleanup bill shortly afterwards, where no longer did we not have those county gun boards. They added language into the law that specifically said that the county clerk had to issue the license based solely on the report issued by the state police. The county clerks asked for that, and I can understand why. They were not in the best position to make the determinations. They felt the state police, who was doing the background checks, was the best position to make those determinations. And so they wanted to say, we don't want responsibility here, hand it off to the state police who are the best to handle it. That's what happened in 2017. So where we stand today, county clerks do not have discretion in this process. They are there to take the paperwork, collect their fees to repay their part, hand the paperwork off through a computer system to the state police, where the state police do most of the heavy lifting, and then report back to the county clerk, who prints and issues the license. There's no reason why anyone couldn't go to any other county in the state and go through the exact same process that they would in any other county. Yes, there are absolutely counties that still do put hurdles in their system intentionally to slow the system down, specifically in Wayne County. We know this because Wayne County told us so. Back during the COVID era, Wayne County instituted a appointment process where you had to have an appointment to come in to simply apply for a license. State law doesn't say that. In fact, state law says that they can't do anything that's not in state law. Gun groups, we sued them. We said, you can't do this. It's not in state law. State law even says you can't do anything not in state law. They then went ahead and issued licenses to all of our plaintiffs, and the court dismissed the case as moot, even though we had constitutional violations in there. They were absolutely not moot. Everyone else since then, with knowing that we were unable to get anywhere in the courts, And with applicants knowing that they're already paying $115, that they're probably struggling to meet, especially in Wayne County, they're not willing to litigate those. So they still have this COVID-era process in Wayne County where they're still throttling the number of applicants that they're taking. They've throttled it down since COVID era, since they do have fewer applicants then, but there's still a waiting period, this artificially generated waiting period. And one of the reasons Wayne County, in its own words, has told us that they do this throttling is that there's a 45-day period that if they don't make a determination within 45 days, the applicant automatically gets their license pending a decision on their application. And in the words of Wayne County's attorney, they have this throttling process so that 45 days is never invoked. That is against state law. They can't do that. That 45 days was put in purpose. Now, we could go litigate again. We could spend money from an applicant, we can spend money from the county, or we can simply let people go to any county that they want to and apply where there is no waiting period. And let that clerk that isn't artificially slowing down the process enjoy the profits that they receive here. Interesting that this comes up right after CPL fees, that we're hearing how much profit the state is making in the system.
Competition.
So I hope that background was useful to you. You understand how we got to where we are, how we started with county clerks, yes, being a big part of making the decision, but that's no longer the case today. I'm happy to answer any questions if you have any.
I think we're all set.
Thank you for your time.
I am going to read in these cards here in regards to House Bill 4980. Does not wish to speak and opposes the bill. Kathy Tang, every town for gun safety. Or is that? I don't know what is it. Town mom? I'm not sure. I'm sorry. Supports the bill. Does not wish to speak. Nick Bougie from NRA. Does not wish to speak and supports the bill. Brady S. from MCRGO. Does not wish to speak and supports the bill. Casey Armitage. And then I need to go back to House Bill 4749 on Rep. Roth and read in a card. Supports the bill. Trevor Van Dyke of the Michigan Supreme Court. All right, seeing no further business before the committee today, committee is adjourned.